Good morning, friends. As those who have been connected with the series of Beyond Law CLC would have seen that Justice Kannan, a former judge from Punjab Haryana High Court, was one of the, I can say, mentors or who had helped to lay the foundation of this series. And we did a lot of sessions with him. And with the flux of time, we saw that Sir, with his knowledge sharing process, kept on growing in different processes like mediation, which is quite close to him. Since his forte is also in the Evidence Act, we requested him that it's a niche topic and there couldn't be any better person that who could explain this perspective of forensic evidence in civil and criminal cases. And as usual, Sir was kind enough to accept this invite from us. And I was sharing with him that after a lot of time, probably after post-COVID, that we are doing some session at 11 a.m. because we never wanted that Justice Kannan, despite his busy schedule, has accepted it. Thank you, sir, for accepting our invite. And before we request Sir to proceed, I would just like to share that Sir is a senior advocate and is a well-known resource person as well as a lawyer in different forums. Over to you, sir.
Yeah, thank you so much, Vikas. It must be a nice wintry morning there in Chandigarh. We are not as cold. In Chennai, it's either hot or too hot. So therefore, I'm in a warm place here. And it's a pleasure at all times to stay connected to persons in Chandigarh. But I know Vikas has grown big enough, is beyond Chandigarh, beyond the geographical boundary. He has probably his own site, has traveled elsewhere. I see some of the persons probably there from, some of them are from Chennai themselves. I'm not too sure. So I'm another advocate, it says. So maybe he's a person from here, yes. So therefore, good to see, good to connect. These provisions of what we have when we are talking about Evidence Act, now we call it by various names. I can't even get these names. I only use the abbreviations, BS, BNS, BNSS, something like that. So therefore, I'm not going to be making any reference to provisions of the Act. But when I said forensic evidence, I thought I should give you a kind of an idea that we are looking beyond the normal evidence of what we see. When we talk about what is said to be proved, the Evidence Act gives an answer that what a judge believes to be true. So therefore, we are certainly substituting an important area of evidence of what is required to be proved through the prism of what a person's belief is. We talk about beliefs in matters of religion. And that's why it is called as faith. You believe in God, don't believe in God. It depends on what you state as the hypothesis. You take it first and then unpeel it. Same way, when we talk about forensic evidence in civil and criminal matters, there are important areas where some more, not merely a belief of what a judge gets, is not in the way that religious beliefs are built. It's on the other hand on scientific evidence of what is provided. When I speak in court, when I tender evidence in court, when I offer a proof of a fact through what I have observed, these are matters of what I believe is correct. And that's whether a judge must believe me or not, gets to be, is Kannan capable of telling the truth? Is he telling the truth really? This will be tested in the cross-examination. But when we are talking about forensic evidence, that statement of what somebody gives is made to depend on certain scientific materials. And I'm going to be making references to two important literature which talks about it, and which I will also advocate to you of what you must go back to. So I'm here talking about a situation where a judge is also, if there should be a judicious approach to evaluate forensic evidence, we talk about a judge who is a gatekeeper, who allows the evidence to be given in a particular fashion. Whether you should give it, whether you allows that kind of evidence or not, is a matter which will be seen. And then we are supposed to be, as lawyers, we are supposed to be playing an important role of being in a position to assist the court. I've heard, in fact, one of your judges now in Punjab and Haryana, he'll always open his case as, if I may assist the court. That's how he'll begin. These are nice expressions of what you don't hear in down south. But then assisting the court is what a lawyer does. So how is this going to be done? How are we going to be really seeing ourselves in that kind of a situation? Now, I'll probably put you through what we mean by forensic evidence. When we talk about a forensic evidence, this word came through Rome, because we always go to the basics. What really was the reason? It's a forum. The forensic came from the word forum, which is a meeting place where civil and legal matters were discussed by persons with public responsibility. And now forensic medicine. Now what has happened is the book which I've been editing from 2005, Modi's jurisprudence of what I'm doing. The book is called Forensic medicine. If it's medicine which is practiced by a doctor, is clinical exercise of what he's doing. When I'm talking about forensic medicine, how that kind of medical facts or what are gathered, how are they brought to court? How that becomes a forensic medicine. Therefore, now the academic circle, the medical jurisprudence itself has become science, and therefore we talk about it. Now, the forensic medicine, when we are talking about, it's apart from a normal civil or matter relating to civil and criminal matters, we have specific areas where we talk about forensic evidence. You can see on the left the thumb impression of so many cases of what we see now in civil cases. Paternity is an important area. Beyond section 112, 113 of the old Evidence Act, where the presumptions are drawn, where a conclusive evidence is drawn, where a child is born within a period of 210 days of a coverture of a man and a woman, and the child is deemed to be born of a lawful relationship of a man and a woman, it's conclusive proof that the person is born to that man through that woman. That a woman is a mother of a particular child is never in doubt, because the child comes through the loins. But whether who is that particular man who is responsible, then it becomes a matter of presumption. And there you need to have a certitude. And therefore, we talk about conclusive presumption. That is the only section which talks about conclusive presumption in the Evidence Act. Now, here now, from the time when 1882 to 2023, we have come a long way in matters of science. There is a method of assessing a paternity is now possible if there is only one person. Whether that person is a father or mother is always possible to say. So paternity issues, when we talk about that, we talk about it in the context of a scientific evidence which is placed through DNA, and that is a forensic evidence. In the matter of execution of documents, and again sees whether a person's signature is that of this person's, or the thumb impression, does it bear that person's thumb impression. These are scientific facts. The manner of gathering and assessing whether it is the signature of that person or the thumb impression gets to be forensic evidence. Determination of age. Whenever we talk about custody of a child, the issue of guardianship becomes relevant, and therefore again matters relating to juvenile offenses, the age is relevant, and therefore matters relating to juvenility, in the matters relating to minority of a person, you have scientific evidence, which is the forensic evidence. Transplantation of human organs, again, the suitability of this person, whether cross-matching is done, whether this could be given or not, that kind of examination. And when a court passes an order authorizing some kind of transplantation, forensic evidence is always sought. Matter relating to mental ill health, now it comes through the what was the Lunacy Act of 1913 grew to be substituted by Mental Health Act of later in the year 1987, and that has been now also substituted by Health Care Act. Now it is not mental health, we are talking about health care, where you give an autonomy to the person. This again, this act contemplates the assessment of where a person is mentally ill. Rights of persons with disability comes through another enactment, where the assessment of how a person is seen as mentally ill or not is done through forensic evidence. medical termination of pregnancy is again a situation of whether the child is if the child in the womb has any instability, as any illness or any brain alteration, brain function which is not all right, and therefore the child cannot be proper, or there is some genetic disorder where there is no nose, there is only hole, or there is only 1 ear. So there are some genetic factors which can take your mother a decision to either to abort or to have it. So in all these matters, you have forensic evidence which is brought, which are of scientific character. Same way in the criminal matters, the most important thing of what we all know, the ascertaining the involvement of an accused, whether he was there at that time present, has he left behind any factors, hair, sweat, his finger, or in sexual offenses, semen. All these get to be very important scientific facts to be gathered from the place. And therefore, the examples of urine, blood, sweat, all these things have immense relevance in the field of forensic medicine and forensic science. Brain mapping, truth serum, lie detector, all these things were outlawed if it is going to be compulsively enforced. What became a matter of mere procedure for police to ask and the public prosecutor to press in the court to subject an accused to brain mapping or truth serum, or put the person to lie detector. In Selvi versus State of Karnataka, the Supreme Court said, speaking through Justice Ravindran, that shall not be done. This is testimonial compulsion. It violates the provisions of the Constitution. So in these matters, again, there are scientific things. DNA already said, the bomb blast, gunshot injuries, all these are whether a particular gun was shot only through that particular, a bullet was shot through a particular gun will be seen through the scratches of what you see. The whole, everything has a peculiarity which is gathered only through forensic medicine, and therefore what I am going to be talking with reference to the civil and criminal cases, or probably many of those things are already there in the book Forensic Medicine, the Modi's jurisprudence of what we have, and where I've been fortunate to be associated with the book for the last 20 years. Skull identification, again, important examples given in the book are from Chandigarh. My association with the doctors there allowed me access to those examination forensic labs. I collaborated with 5 of them from Chandigarh, and all the pictures of what you see in the book of latest edition, if you will look for, you have, there is of course another 2025 edition will be coming next year. But the last of editions of what I was working with was in 2019. And you have all those samples were only taken from persons, and the skull identification, how it was done, how the face reconstruction was done, where you had merely the skull, whether this was a particular person, where there had been a complete disfigurement, how those kind of evidence was taken. It's all there in the book. That's also forensic evidence. So these are the issues which we'll see. And I told you just now of what I'm going to be talking now. It comes through important books. I would want you to note it. I've also told Vikas, I'll make these slides available for you to see. There is a constant, both in USA and UK, there is a automatic feed of scientific materials from scientific community to courts. One is report to the president. You have interesting topics which you say how a scientific community reports it to the president. President gives it to the attorney general. Attorney general gives it across the states for the courts to follow. One such is the President's Council of Advisors on Science and Technology. It is called as PCAST. PCAST report, you'll have to say PCAST. Type in PCAST report. Try and see whatever subject you want to see. And you'll find of the thing, forensic evidence in criminal courts ensuring scientific validity of feature comparison methods. This is a new thing which I'm going to be talking about, because the president's report is a matter of significance, because the the scientific community is at all times concerned and worried that judges apply the scientific tools in order to arrive at important decisions. Matters I already pointed out too, both in civil and criminal matters, scientific evidence becomes clear and important, imperative. And I also identified the areas where it will be done. In all these things, how you should approach the facts scientifically is what the report says. I think it's worthwhile. It's a simple book of this matter relating to scientific validity of several things. Thumb impression, when it can be taken, bite marks, how sure they are, footprints, what kind of importance can you give, DNA evidence, what kind of evidence is possible, how should the report be prepared by the doctor, what kind of questions could be asked before the doctor. All those things are available for you. It'll be worthwhile for doctors, for lawyers to know what this is. And it contains several subjects. You should be able to periodically send it. Again, another one, forensic DNA analysis, primer for courts. This is by the Royal Society given to the Supreme Court of UK. This book is presented the Royal Society. The person who chairs is a person of some Indian origin. For us, it's a matter of pride for us to see an Indian being used for a primer to court. Is prepared by Venki Venkatraman. He was a Nobel laureate. Venki is a person who has prepared this. And forensic DNA analysis, if you must have any kind of cases of what I showed, where DNA is involved, what is it that you need to know? What kind of things are required to be asked? All those important details, you'll find it through that quote. Now, this book gives to you, the Speakcast gives to you, there are two things. This is the significant contribution in this. Any evidence which you bring it, be it a civil case or a criminal case, the evidence must be a robust evidence on law and admissibility will provide a framework for the courts to assess. One, a scientific validity of the technique. It's important that it is scientific, and the technique is again employed by a person who is competent to do that. So the person who does it correctly. And then what else? Whether the scientific principles have been reliably applied in the case in question. All these things would be the matters of importance, because this will give to you a clue about how you would approach any scientific expert who gives evidence. How do you approach it is what you'll be doing through this. Manner of understanding forensic evidence comes through the scientific validity of the technique. First, therefore, what is the technique which is applied when he is talking about DNA assessment, when he's talking about thumb impression? Now, what did he do to do that? How did he get to give this kind of comparison report? Because I've seen as a judge in court, if there is any thumb impression expert, the belief is that the thumb impression science is a perfect science, and therefore it has to be infallible. If it's a handwriting expert, you only say it's an imperfect science, and therefore it will merely start and begin and end with mere suggestions. I'm suggesting to you that this handwriting science is not a perfect science. He will say, yes, yes, my lord, yes, your honor. Say something like that. I'm suggesting to you, you have given this report for a wrong reason. So therefore, we get to have issues like merely giving an explanation that it's all not scientific, you don't really know. So therefore, we keep saying something like that. But we need to know what we can ask. How is the scientific validity of the technique? What are the techniques which are adopted is what is essential for us to know. In a legal context, it gets to be when we talk about in matters relating to investigation. Particularly, I was thinking because forensic medicine and forensic science is applied more in criminal cases than civil cases, where the truth has to be perfect. It is beyond reasonable doubt. Where in a civil case, we are talking about preponderance of probability. When we are talking about civil case, it's less in terms of quality. But you want to obtain a very perfect thing, and that has to be scientific. That has to be forensic. And therefore, insights and information will come from established science and exploratory approaches, and prosecution which seek to prove the guilt of the defendant beyond reasonable doubt. Forensic science must satisfy the highest standards. And what you have through the Evidence Act, now what is the corresponding provision, you will see what the BS Act says. I'm not able to immediately recall the provision. This is under 46, what will bear upon. You'll notice when we talk about scientific evidence, we still talk about opinions. It's never the certainty of what we are talking about is still an opinion based. Opinion is brought in a context of how a person has approached the scientific thing. Now, how do you enable an application of judicial mind? Because we are invoking the courts when we are talking about evidence, when we are talking about forensic evidence, we are trying to satisfy somebody. Why? That he is the person, he is the final arbiter, or he is the person who is going to adjudge on whether that evidence of what we have brought is correct or not. So therefore, what is it done? We are now trying to find out, what do I do to enable the best evidence which is possible in a case like that? And this is where the legal standards and scientific standards intersect. Judges' decision about the admissibility rests solely on the legal standards. They're exclusively within the province of the court, and no expert can substitute that opinion or finding. So, however much a scientist may have knowledge about things, ultimately we are looking to a judge who believes what is to be true. Like I said, I started with saying, what is a thing said to be, when is a thing said to be proved? You find the Evidence Act gives an unusual interpretation that is a matter of faith, it's a matter of belief. That belief is not merely somebody getting a dream, it must be true, or a gut feeling that this man must be telling the truth. It's not like that. It is based on scientific fact. And that decision of what the scientific validity is what is important, and what is proved is what I said is believed to be true. So it is in that context we are going to be approaching the whole thing. And there are, in the matter of this, a whole new approach is given by PCAST, and that is what they call as a feature comparison. Feature comparison is means a process that is employed to find whether an evidentiary value from a crime scene or is or not associated with a potential source. Sample from the, it is based on the presence of similar patterns, impressions, features, characteristics in the sample and the source. Examples include the analysis of DNA, air, latent fingerprints, firearms, spent ammunition, tool and tool marks, shoe prints, tire marks, bite marks, handwriting. Now, you see, I was talking about a feature comparison. The feature comparison is what do you have from a crime scene? Let's talk about some theft. What do they do? They immediately take the fingerprints. How do they take the fingerprint? This is important for a lawyer. A cross-examining lawyer must know that all these gathering of evidence from the spot, how it can be completely violative, how it cannot shed the correct evidence. Arushi case is a case which is a telling example. It's now before the Supreme Court. A conviction which was entered by the trial court was reversed by the High Court, and all persons were acquitted. And the case is before the Supreme Court. In Arushi case, there was a woman who was killed, who was bleeding, who had died. And you find in the same house at the terrace, yet another person who is dragged from the place, blood marks are there, who had been working in that house, he had also died. Now, what was the connection? What were the features which were available? Ultimately, they found the purity of samples had been completely lost, where deliberately or so, and this is what was the prosecution case, that so many people came in there, went out, so many people touched this, that, touched the body, touched the articles around, the tumbler which was there, that were touched by several persons. The purity of gathering the sample became a very serious issue, because when we are seeing the place and want to connect it to a person whom we are searching, whether that person could have done or not, we'll have to bring a feature comparison. Therefore, you need to have a sample which is pure, which cannot be sullied. That becomes relevant. The same way, if it is sexual offense, probably the semen spots there. Again, this can be lost due to heat. It can be delay in taking the sample. All this could have. It's quite a different thing if there is even something like you have a condom there. A condom, like they say, a condom is really a visiting card. There is nothing more certain than gathering material from there and then taking it. But where condom is not used, gathering that, scraping that material and then taking it is going to be very important. Just a minute, I'll be with you. Phone up, take the card. Have to do something. Yeah. See, there's a small distraction. I'm sorry. Taking the quality become very important. The feature comparison of what we talk about. Therefore, and the first attempt must be for a prosecutor to see that there is a purity of sample appropriately obtained. Or when we're talking about a cross-examiner, what is the comparison which you're making? How was the purity assured? Who took it? What were the precautions taken? Where was the scope for somebody else to sully that kind of sample? All of them would become relevant. No, this is scientific validity. How do we make certain that it is appropriately done? It is done like this. PCAS talks about a foundational validity. It must be an analysis whether the technique can give accurate results. Now, when we talk about DNA, when we talk about say blood or urine, any of these things are what would require to be seen. The important thing which a doctor must be able to say, or the scientific community must be able to see, is whether it can give appropriate results. Now, whoever commits this scientific examination must come with the same result. Each one I cannot have a result which is different from yet another person. Then there is something seriously wrong. Same way, whether the result would be obtained several times. I do one test. After some time, somebody else does it. It gives the same result. I do the same thing. After some time, it should give the same result. So therefore, a foundational validity is done through these three things, and where you must see a cross-examiner or a person who understands that. You must see. This is what PCAS say is a very important thing. And that foundational validity of what you have, has it been properly applied? That is the question which will be seeing. A forensic examiner is surely applying only that. He has not done anything else. It's to a copybook style. It is done in the same way. That is the degree of certainty which must come. And that is when it will be properly assured. Now, what do you understand by this foundational validity? I gave you three things, and that is now expanded, and it is understood the essential points of what really go for foundational liability of what can really work. It requires the method must be repeatable and reproducible. It shall provide estimates of the method of accuracy to indicate that the method is appropriate for the intended application. Feature comparison method. This again is objective and subjective. We all understand the meaning of what is subjective. That objective method will be as definite, standard, quantifiable detail which is taken from there. And subjective methods, we mean methods including key procedures that involve significant human judgment about which features to select within a pattern and how it is done. So we talk about things in a manner which will work correctly, and these feature methods must be done. So all this must be, therefore, it is coming through an expert, and therefore, what is the expert going to do? How is the expert evidence going to be seen? How should we approach this? What would require to be done from an expert is, in order that a report has a probative value, it must be on empirical studies. Now, this becomes very relevant because in you'll know, in Nirbhaya case, what happened was, the 5 persons had been arraigned. One of them was a minor, and therefore he had been taken out. And it was a case of sexual assault. they were trying to gather several methods of evidence. They were able to capture it from the cameras, and there was a vehicle going. That's all they could see. They identified the vehicle number, and from there, these persons were traveling at that time is all they knew. They did not have the photographs of all these persons. They go to capture each one of them, and then they subject them to DNA analysis. Their semen was taken from the spot. Then what these persons have, their DNA was taken through scraping the skin or sweat or saliva. These are all the samples which can take. So therefore, all these get to be done. And the issue there was, there were also bite marks. There were bite marks near the pubic region. There were bite marks on the breast of the woman. And where the Supreme Court says, Justice Bhanumati writes in her judgment, bite mark evidence, which is a powerful tool of scientific examination, is it has been properly done from Pune forensic lab, and it has brought out the truth. In fact, PCAST shows, and bite mark evidence is the weakest evidence possible, because when we talk about evidence, evidentiary value, it must have some unique characteristics about the teeth of what the alignment of teeth of what I have. There is nothing unique at all about my teeth. So for you to be talking about the tooth alignment or the bite marks or what are available from a place, it belongs to the particular person. There is no scientific validity at all. In fact, when they found out this bite mark, they found some 350 samples were taken. They were trying to find out from 1,000 odd people, what are the bite marks? Will you be able to finally correlate one bite mark to any of those persons outside? They found it was not possible at all. And they proved, the scientific community proved, that there is nothing unique about a bite mark, and bite mark evidence has no value at all. This became a central and focal point in a later, this Operation Innocence was done post 2016. All the cases where there had been a corroboration obtained only through bite marks had been taken. And they found that there was no other manner of fixing the accused. And they were relying on bite mark evidence. They reversed all decisions. In fact, in the last edition of Modi, I had commented that the Supreme Court had committed, it's not as if Nirbhaya case was wrongly convicted and four persons have been hanged for wrong reason. But for a court to be saying it has gathered the most scientific evidence, this is not scientific at all. We need to know. Even I'm going to be telling you about the same thing, PCAST, which I said you must see. That PCAST shows that the evidence is not thumb impression. How careful you need to be. Thumb impression, which part of the thumb impression you must see. How there can be, not every one thumb impression can be clear, where it can mislead. All these are matters which are discussed in PCAST. I'm casting a lot of importance to that because we are now in a scientific world where we look for the best comparative analysis. We look for the purity of evidence of what you can gather. And therefore, I'm challenging the fundamentals so that we arrive at something which is correct. I remember at the time when I was there in Chandigarh, I was merely asking one of our brother judges who had been very popular probably during his own time as a lawyer, a sound criminal lawyer. When we had the incident there in the 2611 incident in Mumbai, where Kasab was there brandishing a gun and then shooting people. What kind of, we spent over a year, spent about 30 crores of money. What is the kind of evidence which is happening? Why are we spending so much money? I was merely joking with him and then asked, why are we doing? Now, as a judge, as a lawyer, I know, but these are questions which people asked. And that at that time he said, no, that for what is seen in the TV is not Kasab. The person who is coming is not the person. The person you apprehended was not him. Everything can be challenged in criminal case because we literally want a proof to be made to the hilt. And therefore, when we are looking for a proof beyond reasonable doubt, we are looking to the utmost of certainty. And if that certainty is in any way going to be suspicious, then it's a matter for great concern. So it is in that context it was done. And the same way, we must see whether all these standards of proof of what are required to be done are properly applied. The expert in his report should not make any claim or implication which goes beyond the empirical evidence. He must say, we have scientific proof to say that DNA is 99.99% correct, it can't be a mistake. That there is a 0.01% which can be wrong is an important thing, because we are still not talking about 100% scientifically proved correct. Where there can be a problem, how that kind of problem can come, where that variation could be there. It has come about in court as to how DNA sample was not at all times. I'm going to immediately show to you one or two instances of where DNA was not fully taken. And that is what we'll see as an important thing, which we'll see. This DNA comparison method, what we're seeing, where it is a single sample to a single person. Let's say like that Sharma case, where from Bombay, from Delhi High Court, the issue was whether he was a son of a governor of Uttarakhand at the time. So the issue was a particular man, a particular son. So a person who was claiming to be a son. Is it possible to connect? DNA of just one sample against another is never a problem. But where there is a mixed sample, such as a gang rape, where the sample gets to be mixed, to extract and identify each one, to fix it to one another person is not easier at all. So therefore, you need to know that when we are talking about purity, when we are talking about single analysis, DNA don't merely go, it's a DNA analysis, it has to be correct. That is not what can happen. That DNA analysis as an objective method, lab protocol must be very clearly and surely seen. Where mixtures of samples of multiple unknown individuals of unknown proportion, it can happen, then there'll be a problem. You'll not be able to secure the best result, and what is done through court may not bring the right thing. Now, this has happened in a case in a Scott's case, they used to say in UK, a person who was not there in that place at all, who said he had been some 320 kilometers away from that place, and his semen, his DNA was seen in a person who had been sexually assaulted and who had been murdered. So when they saw that this was the DNA and Scott's DNA correctly matched, there was a big surprise, and he was convicted. And it turned out later that I said purity is an important thing. That 320 kilometers away in a lab, he had some throat infection. He had coughed. They had taken the sputum. They had examined in a petri dish, and it had been cleaned. And another sample, when it was taken, that the same plate, that same thing had been used. So therefore, they took a sample from his throat, some phlegm of what he had some time back, just about the same time when there was a sexual assault 350 kilometers away. They found that it had a different, some other experiment when he had some other investigation being done. That sample got mixed with a case which the same lab is looking for comparison. So these kind of things keep happening, and therefore it's important for us to know that it can. That's why I said the feature comparison methods of what we say is between a latent print and a known fingerprint. Bite mark, I already said, false positives are very high. Footwear analysis, these are things which are again brought in criminal cases again and again, that same footwear. Again, there is nothing peculiar about the foot size. If we are there about 25 or 30 or 35 or 50 persons watching now, our size of the footwear of what we have, there's nothing characteristic about that, and therefore you can't get the best sample and get anything proved or done. So we need to know that it is not at all times properly done. But the most important thing is when a doctor or an expert gives an opinion, what should he say? What is the kind of assertion that he can make? Because I said it has to be done on an empirical data. what brings certainty, what is the kind of sample which had been done, what is the scientific community, does it go through this test? Every test which is done will give the same result. Anyone else doing it will give the same result. These are things which will bring a certainty. So that's why when a person writes an opinion, what it should contain, you must examine at all times when you are there seeing, when the report is brought to you, uniform language, even how a report must be given by an expert. The PCAS suggests to the president, where there are empirical studies available, the examiner should provide the quantitative information. What is the error percentage possible? There is no science anywhere where even like a DNA is at 0.01%, there could be a mistake, or there is no uniformity. There could be some person who may have the same DNA elsewhere. Rare possibility, 1 in a million case. But then there is such a possibility is what is required to be stated. If any person says there is in testimony, examiner should always state clearly that errors can and do occur due to both similarities between features and to human mistakes in lab. Where no adequate empirical studies are available, it should clearly state so. Because if an expert is going to be saying, I know this, what I have done is a correct job, but is it correct in some sense? Same way, it applies, what applies to hair comparisons. Again, a person must say, this is likely to be this hair, this person's hair. Instead, if he's going to be saying this hair or what was found there in the place, it is his hair, then that is not acceptable. So therefore, what is not approved, it must be, the examiner must not state or imply that a hair came from a particular source to the exclusion of others. That kind of exclusion he can't make. Examiner will not state or imply a statistical weight or probability or conclusion and provide a likelihood that the questioned hair originated from a particular source. Instead, he can only say it is possible that it is there. It's a possible source of the questioned hair is all that he can assert. This is because we're talking about scientific validity and the certainty. And if there is an expert who is going to be making it as though he has known that he has taken it from his hair, this hair belongs to him, he will not say it is possible that it's there, is what you should be saying, so that the court has a manner of knowing what is the scope. There was a very interesting case from Kerala. This is about a man goes and reports to the police that his wife was bitten by a snake and she has died. And the doctor comes and sees it was a snake bite. The postmortem says that it's a snake bite. But the crucial thing is, this man said, I found out what the snake was. I went out and I killed it. He therefore brought, a dead snake was also there. So they knew which was the snake which bit for sure. But the forensic evidence of what came to was that snake they found, it was a cobra. Cobra cannot claim more than 50% of its length. Supposing it's 1 meter long, its claim can be only half a meter is all it can claim. But this was a cobra and the cot was fairly tall. It could not have claimed. She was lying on a cot and therefore it could not be, was one evidence which was taken. Another thing which they found was the fang. There are normally, it had bitten in the neck area. The fangs were in two places. One, then below there was another one. The court said there, the evidence which was, the forensic evidence which was brought was, cobra is a very shy thing. If it bites somebody, it will immediately slither out. It will not stay around for any longer time. So 2 times it cannot bite. That was another thing which they said. And then again, they opened the mouth to see, and what can cause that kind of a fang, that bite mark of the 2 teeth of what they have. It had been actually broadened. It was wider than what the normal size was. If you clutch at the neck of the cobra and to make somebody bite by voluntary process, then that bite mark can be extended. It cannot be narrow. This is how they found. So therefore, even a thing, forensic evidence of where you have an example, where you bring out a sample from a place and then want to show, there are so many things which will go into reckoning that a doctor could not have said, yes, I've performed the postmortem. The person, this person must have died only by this snake. To that extent, it could be all right. That snake accidentally bit the person, or it came there to do it. They found this must have been actually placed on that person on the bed, killed the person with the snake, pressed it. She was suffocated. She was made not to get up from her place, and then snake was given 2 times, applied on the body 2 times where it bit. That was the kind of evidence which came to be done. I'm talking in that sense as a forensic evidence, because what he will state and what he will not state. This is, again, I'm not going to run you through this because we'll be soon closing if it's going to be an hour. But then these are contained there. What an expert must state, if it's a footprint, what he will not state. All these are matters of importance. Again, the same way in DNA analysis, what can be stated? Validity, how it is. What is the level of certainty which is possible? How can you apply this result? Where could it have gone wrong? All these are matters which can be surely seen. In all this, again, you must notice, when I was in Chandigarh, I went for, because I was writing a book on the Moses jurisprudence, I took the permission of the doctor there, and I was there for a postmortem. I had at the time, when I was waiting there, I was being taken to the forensic expert and the doctor who was going to perform a postmortem at that time. The police who comes and then comes to the body, then hands over the body to the person. Then that man says, the police tells a person, which is recorded in the register, madam, there was a nurse there. A stove burst case, madam. She was cooking and the stove burst and she died. And she had all burns on her body. That was the body which was there at the time when I went for postmortem. Now, the doctor is informed like that. There is a stove burst. Therefore, was she close enough to a stove? Which is the part of the body which had been burnt? These were the issues. Now, he was going in and explaining all the students. See, it's a stove which burst, and then she has obtained burns. And that is the postmortem which you are going to be doing. I was asking as a very innocent person, because I had known what this bias can be there. Because the doctor, even before he performs, he informs others, and that is what he is going to be doing. How a cognitive bias comes through an examination. It could be similar. Like in Tiwari's case, there was a bias already in that governor of Uttarakhand, whose son, a person claimed to be his son. The issue was, how do you say is his son? That is what we need to prove. Are we matching? There is one-on-one was always possible. But then there is a bias at all times come. Who brought it? So in the cross-examination, who brought the sample? What was the evidence which is given? What was the statement which is given? What have they recorded there? All these are important, because there could be confirmation bias could be there. The contextual bias would be, irrelevant information would have been given. Proficiency testing for all that, examiner's capability, whether he had the necessary qualification, how many tests have he done. In Arushi's case again, the person who carried out the postmortem said he had not seen. Look at, he's a young man of 26 years or 27 years. And young doctor, I don't know, he must have seen also some postmortem. That's all he did. Have you conducted any postmortem? He says, no, I've not conducted any other postmortem in a previous case. Have you examined the internal parts of a woman's private part? He said, I've not examined before. So the proficiency of the person was itself brought in challenge. And the High Court, when it was acquitting and reversing the decision of a trial court, found that there was very serious lack of proficiency for this person who could have taken a correct decision. So therefore, those are the issues. I was saying now, when we're talking about purity, the chain of custody is important. I already gave you the case of Adam Scott. That is the example which I've taken, where somebody had sputum which he had given, the chain of custody, who holds custody of the sample, where was it brought, how was it done, If only you go to the forensic labs and see, you'll be surprised. So many things will be there in a fashion where no kind of attempt at purity would be there. So much of contamination would become possible. It will be open. All these are things which are real. That is the way we conduct our things. Many times, the doctor with whom I was having a discussion, he said many police, they don't know how to keep the purity of sample. They'll simply take it in some cloth and then deposit somewhere. They will not know what it is like, and they would have put it in somewhere placed nearby the window where, due to aeration, due to heat, due to sunlight, the purity could be lost. All these things are important. The chain of custody and how it has happened are important. This is why when we are talking about forensic evidence, there are at least 6 areas of what we must care ourselves about. Collection methods and conditions, how was it done? Was it assured? Was it capable? Was it correctly taken? Was the sample correctly taken? The chain of custody of what I was saying, like in Adam Scott, where the custody, where it had gone, how this particular material had been gone. The purity of the forensic sample, non-tampering, deliberate tampering could be there, medical condition of the attacker. See, this again becomes irrelevant in sexual offenses. They examine the person, his private part. Does he have any blood anywhere? Does he pass blood? Does he complain of pain in the private part? All that will become relevant. So therefore, you must again say, in the manner we collect evidence, there are limitations. The manner that we apply some test, there are limitations. That in the present technology of what we use and some materials of what are there, they have surely matters. This is again, purity is what I'm coming. And could be issues of mistaken identity, absence of sperm in many places where a person uses the condom and removes the condom, also takes away. There'll be no, you won't be able to find anything. Absence of spermatozoa, if it is there, how else will you be able to see? DNA, what other samples are possible of being taken? Is it adequate? All these things would become important. Physical evidence, it will add to strength of how it is done. I was telling you of certain blunt force injury to female genitalia where it exists. What is the injury type? Where is the site of where it is? Direct bruising or abrasions or lacerations, it could be in any site. Certain injuries can be in some certain types only. It could be a crush type, it could be bruising, lacerations. These are things which you will have emphasis on. I'm not going through each one of them, but I want you to know that you need to categorize what is the mechanism which is used, what is it said to have been done. A direct impact is a frictional force. If it is a laceration, it should be frictional force. If it is friction, where could it be? Any part of the body? This is how, when you have an injury where somebody, sexual injuries, when we are examining, all this would require to be seen. And as I'm concluding, I would only be saying, judges at all times, that's how I began, is a lawyer, as an officer of court. First of all, be mindful about the foundational validity, that the foundation is strong, it is appropriate, it is taken, and the validity is properly applied. It is done by a person who is competent to do, and he is giving you the error rates. What is acceptable, what is not acceptable is surely given. So if that is done, and then post-physical manifestations, how they are done. One expression which I've used is dyspareunia, where the person has pain post-sexual contact, where he has pain in the organ. And these gets to be urinary tract infection if the person has, does he have. All those things will become important. And I'll close it with this. When an expert is brought, test his credentials. Test his scientific knowledge. What is the knowledge which he claims he has? And then ask the expert to read you must give the evidence like this. I examined such and such a person. It's a BE handwriting expert or a thumb impression expert. I examined him. This is the report. That's no good. You must read everything of what is stated there in the court. The evidence must be given of what he has seen, and not because sometimes we believe it's there in the document, Your Honor. is not sufficient. What is there in the document when we're talking about scientific evidence, he has to set out every word. And that word must contain, if there are technical words, that must completely be demystified. You'll have to give away those difficult expressions to what it, by a dictionary meaning, what it means. And you'll have to look to ask him to say, where do you have come by this kind of conclusion? Where is it stated? What is the scientific journal which you're relying on? What is the basis on which you're saying? Be a thumb impression expressed, you should still be asking to say, what are the parts which you have seen, which enables you to make that comparison and come to a final answer. You may not find all of them giving you a correct answer. It's important that we do that, because a conviction, when it is rendered, it must be 100% correct. So, and you must at all times say that it is a probability which is talking about. It's never 100% sure of what can happen. So therefore, these are important areas of what we should truly be concerned. And if only the experts' credentials and each one of these factors of what I'm bringing out appropriately proved, it can be taken that a proper evidence is given. In the manner I've presented the case before you, I've not cited any one case law. I've not given you any particular section. I was only telling you of the limitations of science, of where we are looking for exacting standards, where we need to keep that. How do you try to secure that exactitude? How do you try to see the comparisons? So forensic evidence in situations of what I explained in both civil and criminal cases, you'll be looking for very high standard of proof. And therefore, your own knowledge must be appropriate in a context. And the two books of what I had said, these are all small. The primer for courts is just in about 35 pages. And the PCAST report is in 160 pages, very easily readable. Both of them, this is what I've presented to you, is completely from these two books which I've seen, which I've used in my book also in Modi's jurisprudence. So thanks, friends. I close it now, and I leave it to you for anyone who may ask a question about the validity, scientific validity, how much can be believed or can't be done. So all those, I'll leave it to you. Yeah.
As usual, the session was spot on, and there are a lot of brownie points. And once we share this PPT on the Beyond Law website, people would actually learn from it, because they can download it and then understand more. We don't have any questions, sir, on the chat, but I will just check it out on the YouTube. There's only one question. So could you address on the forensic laboratories for assessing the age of ink and paper? How do you do that?
Forensic lab?
How do you assess the age of the ink and paper?
Ink and paper, what?
Age of the ink and paper. Let's assume there's an old paper. What is the age of that?
Okay. Now, see, this again, you have thankfully some expressions there in the PCAST of what material make it available to you. It's not easy at all. And it's not a very perfect science there. And that's what you say. The ink, and they say the dryness of that ink can be there. But you can't say if it is dried up fully, this is 1 year old, this is 10 years old. You can't do that. Though we talk about when we have some document which is an old one, the paper can age easily, but the ink, the age of ink, if it is old beyond a particular time when it is fully dried up, they say it is not very accurate to see. But the age of the paper can be, you can fake it again. This would lack a foundational validity, because these are matters of immense value, and they say it's not very, very certain. So therefore, if you ask me that age, a paper which is aged, which is old, you can say how many years old will not be possible. So for you, if somebody is going to be saying 1 month, you can fake the age of the paper by fumigation. You may add things by some chemicals. So much is possible by making a faster decay of material. Without the paper getting torn, you may be able to apply some chemical. The question could still be, has any chemical been used? a natural decay, what takes place, then how it is accelerated could still be a matter. Where a chemical is applied for aging the paper, by look at it, you could be the same thing, but it should be possible for somebody to be proving that there is a chemical used. But you must remember, even paper, when they are made, a lot of chemicals are used. For instance, there is a reason for making it white. The whiteness comes through application of certain chemicals. The whiteness are there used. So therefore, it is possible to see whether any chemical is used, but that chemical or what is used, to what extent is a thing which is relatively new or it is old, will be possible. So what goes for making a paper white or coloring a paper through application of chemical will be different from the pure decay of a particular paper, which would be relatable to age. So therefore, it would look for a lot more scientific detail of chemical use and natural, otherwise accelerated. That kind of evidence is what an expert is required to examine. Therefore, when such a report is given, you will have to again say, what is the certainty that this could be accepted by the scientific community as correct, valid? What is the basis on which you can say? All these are important questions which has to be tested at the time of cross-examination. And what has gone by the expert's hand, what has he seen for him to assess that the age and the old age is not by any accelerated process, but it's natural. That's how it will be seen. I see Anurag Jain and Dr. Satish. May I call Anurag? You have a. So therefore, in terms of, you have raised your question. Anurag, please go.
Anurag को unmute करते.
Unmute.
So we have asked him to unmute himself.
Please go ahead. Unmute.
Sir, good afternoon. Sir, I just want to ask a question. Whether an expert, whether a report of an FSL in a civil matters where the forgery of a signatures is an issue, can it be read into evidence by simply exhibiting it? Without, and it's only in a report, without any supporting documents, without pictures, what are the curvatures, etc., without any comparison? Can it be read into evidence?
No, it is no good evidence at all. In fact, see, what makes possible under CRPC, that you don't need at all times the experts to be brought, the expert report can be taken. It's not how it can be seen. Even if the standard of proof is less there, you need, if there is a report made, if it's a fingerprint or handwriting, that handwriting features, because you should be able to cross-examine to say, the handwriting may vary depending on the mood of the person. One, the sitting position, the angle of the chair and things, the angle of the paper in which is held. Your attempt must be to see what can improbabilize what he is saying. But the person who, therefore, these are things which he must have taken care of. Those are the uncertainties which remain. That therefore the foundational validity of what you can say, that there are unique features about handwriting could be there, while thumb impression has the unique feature, handwritings do not have. That is what you have. So therefore, I will not take a handwriting expert's opinion in the court simply by its production. I would be looking for the handwriting expert to come there. You must say what were the sample which are taken for comparison, and all those require. You must also say what is the input which was given, where was he writing, what age was there, the uncertainties about the handwriting, the inconsistency of handwriting at various times of the day. All that will have a bearing, and therefore all that has to be elicited properly in order to make it scientific and acceptable in court.
So simply tender would not be...
Not at all sufficient. There are case law like that. A handwriting expert can't merely put his report. A party cannot put the handwriting expert report and then say it is acceptable. Will not be acceptable.
And if it is from an FSL also, then the same analogy.
Same thing. So that's why I said in CRPC you have some provision. Now in the new act also you must have, I think it is section 192 or something, which says that it's not necessary at all times to require the presence of a scientific officer. You have an exemption like that. But then you must improbabilize how that cannot be relied on in this case and why its presence is necessary. And that is what become relevant.
Thank you so much, sir. Thank you so much.
Satish, Dr. Satish.
So we have asked Swaminathan. Meanwhile, we can take the question from
Satish has put
Ashwin.
his hand up, therefore I was looking
Yeah.
for it.
Can investors get signature samples of accused for second time?
No, but see, ultimately, if you're looking for a court to do it, it can always do. You're talking about second time, therefore, I would understand the first time when it was taken, you have a doubt whether that person's handwriting was taken or not. Otherwise, both in CRPC, it allows for some, it's not taken as testimonial compulsion at all. Examination of urine, examination of blood, all these are permitted to be taken, handwriting to be taken, that also is possible. These are matters of gathering evidence at the time for the purpose of investigation. Therefore, it is all right. It is there, provided there. Otherwise, a court's power to do things, because when you have under Section 76, even a power is given to the court to compare what if the expert had done and that comparison is brought, it will not be sufficient. But the court, if it can take to itself that thing, it can always you can always do that. There is nothing wrong in bringing a comparison. So therefore, that's how I would see. So court, can it do? Probably court is possible. You can take it the second time. Swaminathan, what does he say?
Yeah, probably I think, sir, very good morning to you, sir. Probably the first thing to be done is to test the credentials of the examiner before going into the report.
Correct, so correct. The credentials are normally assumed. If he carries a degree, or where he says he is coming from a FSL lab or something like that, we take it as easy. Never take it as full, because the credential of a particular expert of a particular job must be there. He must know his limitations. He must know what are all the things which are not fully scientifically acceptable. Therefore, run through a quick audit before you undertake a cross-examination, or before a judge. If you are a judge, you must know what is the relevance of this thing. What is the certainty of this? You must look to see this. If we are going to be convicting or finding a particular fact only on the basis of evidence of what is brought through an expert, you must know there is no expert who can assure you of 100%. You must take that as a corroborative piece and never as a singular incident of what is relevant. And that is what is important. Even the forensic evidence, where you're looking to forensic evidence because you want to scale up the quality of evidence, that is surely to be done only on clear proof that the person who gives the evidence is competent to do.
Thank you, sir. Thank you very much.
Dr. Satish.
Satish Katil. Satish Kattimani.
No, sir.
No.
So these were the questions, sir. And thank you for sharing the knowledge despite your busy schedule. And we are grateful to you, and we will keep on connecting with you. Thank you.
Such a pleasure. I'll share with you the PPT that I have.
Yes, sir. We'll post it on the website.
Right then.
Thank you.
Okay. Bye. And it's a pleasure. I'll leave now.
Thank you.